All right, well, welcome everybody. I'm attorney Justin Randall with Hooper Law Office, and today we're going to be talking about understanding Medicaid eligibility for specifically for assisted living facilities, skilled nursing facilities. What does it take to be Medicaid eligible, and what are the rules that you have to follow, and what type of planning can be done. Before I go into a lot of detail on things, just a couple quick housekeeping items. This is interactive, so you can submit questions to the Q&A function. If you click the Q&A box, I'll see those come up if you have anything that comes up as I'm talking. And then also there will be a couple of things that you'll receive from us after this is over via email that you use to sign up. So this chart of a house, sort of, what type of planning can be done for homes and what can be a concern of, I guess, the common planning that people use with real estate when they're gifting it over to the kids as opposed to using some other form or other tool to protect that house from long-term care expenses. What can be some of the risks? And it just gives you a good summary of some of the problems that we run into with some of the common things that people do when they're transferring the home. And then also you'll receive a feedback form that allows you to fill out and give us any feedback that you have, of course, but also allows you to let us know if you would like us to reach out to you to set aside time to talk or meet with one of our attorneys, whether it's just related to estate planning, Medicaid planning, especially if you're concerned about a loved one needing to go into care soon, please let us know. And then we'll set aside time to meet with one of you. And that is a complimentary initial consultation. So there's no fee to come in and talk to us. And we can give you a pretty good idea at the end of the 2-hour consultation of what we would recommend for your situation and based off of the information that we go over with you. And then just a reminder that next week we won't be doing a webinar. Instead, we're doing our in-person public seminar at the Neville in Green Bay, Neville Public Museum in Green Bay. So that'll be 2 p.m. and 6 p.m. There's 2 different sessions. If you want to sign up for that, you can do so at estateplannинglive.com, or you can call our office and we can get you signed up as well. To get started, when we're talking about Medicaid eligibility, a lot of people have misconceptions when it comes to long-term care about what specifically is used to pay for that care. A lot of people think, well, shouldn't Medicare pay for that care rather than Medicaid? I thought Medicaid was just for people who were maybe really low in income or had very little in assets to pay for care. And while that's partially true, Medicare only will cover about 100 days of payment for care. And even then, they don't cover the full value of that 100 days. Medicare will pay for rehabilitative stays in an assisted living or skilled nursing facility. So like in theory, I could be in a nursing home if I had hip replacement surgery and needed rehab for it. I mean, that's that possibility, right? It doesn't necessarily have to be someone who is in their 80s or 90s. It could be someone in their 50s or 60s who had a pretty significant surgery, right? So that's what Medicare will cover. But they will try to end that coverage even sooner than those 100 days by using the standard they have, using it incorrectly, in fact, saying that, well, you're not improving, so it's not rehab anymore. Now you're there permanently, or you're just paying privately. And that's where you are paying out of pocket. Just so you're aware, though, the standard Medicare should be using is that but for the care being provided, that person would decline further, which I don't know of too many people who are receiving medical assistance who would not decline more quickly without that care being provided. So there's been lawsuits on this. They've lost, but they still use the standard incorrectly. So just be aware of that. Once Medicare is over, though, you might not still be Medicaid eligible in terms of your assets or your income. That really depends on the situation, on the assets that you have, on how expensive your care is, and what your income is. But that's where you're privately paying, and you'd be privately paying until one, your cost of care increases beyond your income, which for most of us would probably be right away. Care is expensive, but let's say you're making $6,000 a month in retirement and your cost of care is $5,000, right? Like that's your income still higher. You would not be Medicaid eligible with that. Your income must be lower than the cost of care to be Medicaid eligible. You have to have that, what we call a shortfall, the difference, negative difference between income and cost of care. But on top of that, they also look at the assets that somebody has. Medicaid will look at what you have and say, here's what you get to keep. And what you get to keep is going to be very different depending on whether you are married or single. Single people in Wisconsin, it's pretty straightforward. You can keep your primary residence, but they will place a lien on it as they provide care, and they can recover against that lien after you've passed away too, or if it's so, if the home is sold, they can recover against it too. So while they don't necessarily force you to sell the home right away as a single person, it's not protected either. You can keep life insurance of not more than $1,500 face value total. Now, this is something to be very careful of with Medicaid because they will apply the standard incorrectly. Face value of the policy is, the original amount that you have. This is what the face value specifically is, what the policy is for. So like if I have a life insurance policy for $1,000 from my credit union, that is the face value. Once that total face value is under $1,500 though, then any cash value that's accumulated is not a countable asset. So, you could have and this happens occasionally, a $1,000 life insurance policy face value, and that's the only policy this person has. But then the cash value is maybe $5,000 because of the premiums being paid over time and building up. Well, that $5,000 is not a countable asset for that person then, because it's the face value of their total life insurance is under $1,500. Where this gets applied incorrectly, but sometimes is where the person filing the application or reviewing the application says, well, that's not the face value is the death benefit, not the face value specifically. It's the amount that would pay out at that person's death. And that's something that we ourselves have actually won multiple fair hearings on, which is where challenge any sort of Medicaid denial in front of an administrative judge. So just be aware of that it's $1,500 face value total, and that is the contracted amount, not the death benefit. But if you have under that amount of life insurance, you can certainly keep that without it being countable. Things like term insurance, by the way, they don't have any cash value. So it doesn't matter if that policy is, $1 million term, it's not an available asset. There's nothing you can get back out of that. The single person can keep one vehicle regardless of value. So, ideally, if you had multiple cars, you'd want to keep the one that's the highest in value. My joke is always that's the time to go buy the Ferrari if you ever wanted to do it. But in all seriousness, don't do that. That's horrible planning. But, in theory, you could have a Ferrari and that's your exempt vehicle. But ideally, you want something that can help you get to and from appointments, traveling, things that are easy for you to use. And then other than those things, you can also prepay your burial expenses up to about $15,000, for yourself, for your kids, for your spouse. And that's not total, that's per individual. So, this is something that people will often do as a way to spend down. They'll prepay their burial expenses. Now, when you do that for it to not be an available asset for care, so that you wouldn't have to cash out that policy to pay the facility, it must be irrevocably assigned for that purpose. You can't get the money back. Otherwise, that is an available asset. But other than that, a single person can only keep $2,000 of all their other assets. So that's bank accounts, retirement accounts, stocks, bonds, right? Like all of those things, cash value of life insurance policies. They have to be below $2,000 in assets as a single person to qualify for Medicaid. Once they are on Medicaid, they have to stay below that as well. And they can only keep $45 a month of their income for what is their personal needs allowance. Now, that number sounds incredibly low because it is, but that number was set when the law came into being, back in the 60s, and has not been adjusted up for inflation very clearly. So it's important to know that you don't get to have a lot of income for ancillary expenses that come up while you're on Medicaid in a facility. So Medicaid will cover what your needs are, but it might not cover certain quality of life things that you would like to continue having. And they just won't cover that expense. I had a client, for example, who had a wheelchair that was an electric wheelchair that broke down, and Medicaid would not cover a replacement because the facility had, traditional wheelchairs, right? So non-motorized wheelchairs. And this was something that was thankfully they had the ability from family members to help purchase a new one, but this could have been a problem for quality of life, right? So it's just important to know that that $45 a month is what you get to use to spend on other things, or your $2,000 in assets. And that can be very difficult once you're on Medicaid. For a married couple, it's a lot different though. As long as one spouse is living at home or is not receiving Medicaid assistance, so if they're what we would call the community spouse, the one not receiving care, they get to keep the home and there's no lien being placed on it. So the one primary residence they get to keep, they don't have a lien that they have to worry about as long as they're still able to reside in that home. The healthy spouse can keep that. Any of the community spouses' 401ks, IRAs, 403bs, qualified retirement accounts of that nature, anything that's in the community spouse's name, the one not receiving care, is completely off the table. It's not counted as an asset for that other spouse's care. So this can be both great and a nightmare, depending on which spouse has more of these accounts and which spouse has care needs first. So, when you look at the sort of old school traditional marriage that, the people who maybe 10, 15 years ago in particular were the ones in need of care, it was very commonly the husband who had most of these accounts. And also very commonly the husband was the one who needed the care first. So that meant that their qualified retirement accounts were potentially available for their care. And that could make care unequal between those two spouses, what was available for them in terms of payment. So if you are the healthy spouse, your retirement accounts are exempt. Now, the spouse who's in care, it gets added towards the total that you're allowed to keep. It gets counted as an asset. All the other things with like the one vehicle, the life insurance, prepaid burial expenses, that's the same for both spouses, and it is both spouses as well, other than the one vehicle total. But all the other assets that I didn't mention, so things like bank accounts, regardless whose name they're in, just traditional investment accounts where they're not IRAs, 401ks, individual stocks, bonds, cash that's lying around, additional real estate, right? Additional vehicles, all of those things value-wise get added up. And then Medicaid will look at whatever that total is and say, we're going to divide that in half. And that is how they figure out what the community spouse gets to keep of those assets, what the other spouse would have to spend down through, if you've heard that term before. The minimum that they can force a community spouse to spend down to from those available assets is $50,000, and that's always the same. So if some married couple is already below $50,000 in total assets, they would already be qualified for Medicaid if one of them went into care, potentially, as long as their income was lower than the cost of care. But the maximum that community spouse can keep of those available assets currently is about $138,000. So if Bill Gates went into care, and I know he just got divorced, so this doesn't really apply as much anymore, but if Bill Gates were married and his spouse went into care and they were looking to get on Medicaid in Wisconsin, he would still have to spend down his available assets down to $138,000. That's the max right now that you get to keep. If your half of that available assets falls between the 50,000 and the 138, you keep exactly whatever that half is. That's what your number is that you have to spend down to. So, in theory, with that IRA 401k of the healthy spouse being off the table for their spouse's care, the primary residence, and then up to about $138,000 of other assets, they could potentially have a couple $100,000 or $500,000 or $1 million if that's what's in their IRA, right? So what that situation looks like for a community spouse is going to be wildly different than what it looks like when a single person is on care. And it's very dependent on not just how much money they have, but what types of assets they have that money in. Is it primarily in 401ks, or is it not at all in 401ks or IRAs, right? It just depends. So a lot of people, though, have to spend down quite a bit to get to those values. And I'll talk about some of the ways that people do try to do that in a second here. But just one last thing on the community spouse that you should be aware of is they can keep all of their income. So I don't care if they're making 20 grand a month. If their spouse is, their income is less than their cost of care, and that spouse is in care, that community spouse can keep all of the income coming in their name. It doesn't matter how much it is. So that's just something to be aware of in Wisconsin, that, hey, as a community spouse, you can keep all of your income. Now, what if the spouse who's in care had the majority of the income? What happens in that situation? Well, in the situation where the spouse living at home is under about $2,800 a month in their own income, they can shift enough of that other spouse's income over to them to get up to that point. So in theory, if both spouses together are a total of less than $2,800 in income per month, then the community spouse will probably get to keep most, if not all, of that income for their own personal use, and the other spouse will then, have Medicaid paying for their care. Where this can be a bit of an issue is where the spouse who's in care has the majority of the income, and they are relying a lot on that other income then, for their personal needs that they have together. If that spouse has a big gap now in what they used to live off of versus what they can now, because maybe they were used to living off of $4,000 a month and now they have a total of $2,800, that can be a bit of a change of quality of life for them, and they're going to have to potentially do some different budgeting than they were before. But so when people are trying to plan to get down to these amounts of what they are allowed to keep, this is where you often hear people talk about, well, should I transfer things to my kids? Should I gift things over to my kids in anticipation of this? So that I can get around this being an available asset so that I don't have to worry about spending down through all of this. And this is where, if you've heard of it before, this is where that 5-year rule comes into play for Medicaid. That 5-year rule is the day you apply for Medicaid benefits, when you submit that Medicaid application, Medicaid will look back the previous 5 years at your statements, at things you've done, and you have to affirmatively tell them to. You have a duty to inform them yourself of all of the things that you've done gifting wise or less than fair market value transactions. And if you've made those transactions over the last 5 years and you've gifted things away, they will total up the amount of those gifts in fair market value and give you a number of months that they will not help pay for your care based off of the value that you gave away. So they have a number that they divide that by, and this year it's about $9,300, just to give you a flat number. So if somebody gave away $93,000 within the 5 years total before they applied for Medicaid benefits, that would be 10 months that Medicaid would not provide assistance for their care, roughly. So it can be very dangerous when people gift away without knowing these rules about that 5-year look back, or about, how are we going to pay through this penalty period if we accidentally create one, because you can be stuck where you don't have any money left now. In order to be Medicaid eligible, you have to be below what they say you can keep. But now the people you've gifted it to, what if they don't have that money anymore? What if they've used it? What if they're not able to give it back to you because of their own legal liabilities going on with like a potential divorce or a lawsuit or creditor issues, right? I mean, so it's not very safe to gift it over to people directly in a lot of situations, because there's a lot that can go wrong in that period of time too. And especially when you're doing that gifting without talking with an elder law attorney who can guide you on, here's the consequences of that gift, just be aware of these things. A lot can go wrong where you don't have a real easy way to get out of that hole that you've created then. So gifting, can be a strategy that people use, but it's also something that when you're doing it sort of just freely without any sort of guidance, it can be just as much of a liability. And there is no safe haven amount that you can gift away per year under Medicaid's rules. So where people ask this question a lot is, I thought there was $16,000 per person per year that I could give and not have it be an issue. Well, with Medicaid, they don't care what that rule is. That's the IRS's gift tax exclusion. So what that means is if I gave to my friend, $16,000 and I was under that, I didn't go over, I wouldn't have to file a gift tax return with the IRS. That means then that my end of life estate tax exemption doesn't get lowered by the amount I went over either. So, I have, and everyone in Wisconsin has $12.06 million that they can give above that $16,000 per person per year or at the end of their life and still not have to pay tax on it. So most of us don't even have to worry too much about that gift tax exclusion. But Medicaid does not follow that gift tax exclusion. That's the IRS's rules. They do not care what the tax consequences of that would be. They say it's $0 that you can give away. So you just have to be very careful that you're not accidentally creating a problem by following guidelines of a different government agency. And as we all know, government agencies don't always play nice together. They don't always follow the exact same guidelines or rules, right? So you have to know the government agency you're working with, what are their rules, and Medicaid does not allow that $16,000 per person per year. Now, there are some exceptions to gifting, but they aren't something that you'd really overly want to rely on as an overall strategy, just because it can be, you have to prove to them that that was an exclusion, that you were, or exemption for that divestment. You were not gifting away money, as a divestment. So they don't have to prove that the gift was a divestment. You have to prove that it wasn't. And so using that as a strategy can be really, really difficult, and not something I like to overly rely on. So a lot of people then will still try to get around the 5-year rule and say, okay, what if I do all this way more than 5 years out? What happens then? And if you get beyond the 5 years, that just means Medicaid can't see anything, beyond that point. So if you went into care and needed Medicaid right away, 5 years and 1 day after you made gifted the entire estate over to the kids, that would be outside the 5-year look back period. But when people come in and ask us if that is a good idea to give that directly to the kids, my usual response, and under most circumstances, the answer to that would be, it's not the safest way to do that. There's a lot of things that can go wrong. And that's one of the charts that we're sending to you guys, is it kind of runs you through some of the things that can be a concern with that. So we use the home as an example, but this can be a lot of other assets too that this applies to. It could be cash as well. But there's, when we talk about planning for long-term care, one of the things that we want to maintain as much as possible is control, whether that's control over assets, control over choice, control over living arrangements, or spending, right? I mean, control is very important, especially as we age, and we want to maintain that. But the number one way you can lose control over something is you transfer ownership over to them. So if you give the home over to the kids, they now have all the control over it. If you don't have any other sorts of agreements in place that say you have the right to reside there in exchange for paying property taxes, things like that, the kids can evict the parents. They can sell the property. They can, do what they want with it. They're essentially a tenant in their own home now. The parents are. So you have to be very cautious with, if your concern is losing control, that's the number one way to lose control. And hopefully your kids are better than that, but it just highlights the possibility of it, if nothing else. Probably a more common concern that people have with estate planning anyway, though, is one of taxes, right? So when we're dealing with real estate, a common concern is, what about the capital gains taxes that my kids might have to pay when they sell this home? Well, when you bought your home, the IRS essentially said, and this is a huge oversimplification, but the IRS essentially said, whatever you paid for your home, that's your cost basis. And when you sell your home, the difference between that cost basis and the sale price, that's your capital gain or loss, depending on the difference. Well, if it's your primary residence and you've lived there for 2 of the last 5 years, you and your spouse each get a $250,000 capital gains tax exclusion from that. So most of us would have to sell our property for either $250,000 if we're single, or $500,000 more if we're married than the initial purchase price in order to have a capital gain tax to pay on the primary residence at all. Well, when you gift the real estate over to the kids, the IRS says, we're going to say you just told them they paid for it, whatever you did back however long ago. So if you bought your home in the 60s for $30,000 and it's now worth $250,000 and you gift it over to the kids, the IRS is going to say that their cost basis, what they paid for it, is $30,000. Now, because it may not be their primary residence, and if they don't live there at all, it's not their primary residence, and they sell it at any point after that transfer, they're going to have to pay 15 to 20% on the capital gain, the difference between that $30,000 I mentioned for the cost basis in this example, and whatever that sale price is, they're going to have to pay 15 to 20% on that difference. Now, the better thing that you can do is when somebody inherits property, it's passed through the estate, whether that's through a will, a trust, or some other transfer after someone's passed away. They get a step up in that cost basis up to fair market value. So in my example of that $30,000 cost basis for that home, it gets stepped up for the kids, whatever that fair market value was when they inherited it. Well, then if they turn around and sell it after you've passed away, they don't have to worry too much about what the gain is, because they're very well likely, may not be a gain at all, or a very small gain. So it depends on how long they hold on to it, obviously, and what the market is fluctuating wise for real estate. But it's at the very least going to substantially minimize any capital gains tax that they would have to pay by inheriting it rather than being gifted that property. So it's just not good tax planning to gift real estate over to the family members while you're living, if you expect them in particular to sell it after you're gone. Now, there are obviously exceptions to all these things. There are situations where maybe family members aren't planning on ever selling it, and then maybe that capital gains issue is not as big of a deal for the next generation. But it's still something to keep in mind. If you don't have to create that problem, why would you? But really the biggest problem with gifting any sort of asset over to the kids while you're alive and having it owned by them is anything that happens to them happens to what you've gifted to them. So with your home, with your bank accounts, with any sort of cash assets that you've gifted over to them, if you were expecting them to potentially be able to use those assets to help supplement your care once you're on Medicaid, well, what happens if one of them gets sued or gets divorced or files for bankruptcy, right? Or passes away? What happens to those assets? Well, whatever's happening to them happens to those assets. So you don't want to protect your home from long-term care, make it well beyond the 5 years, and then just have one of your kids, file for bankruptcy or get sued for some reason or file for divorce, right? I mean, that can impact who owns your home or what liabilities are attached to it. So, by gifting it to the next generation during lifetime, you may very well be creating more problems than you're solving. And part of that is you hope nothing ever comes up for these kids, but it's hard to guarantee that that won't happen. Even the most responsible people in the world have these things come up unexpectedly. To give you an example, we had a family come in to talk to us after they had gifted the home to the 4 kids. The parents had gifted the home to the 4 kids and made it through the 5-year rule. I don't know that they ever needed care even, but in the period of time between that gift and when mom and dad both passed away, 2 of the 4 children passed away as well, which meant their quarter of the home each was subject to whatever their estate plan said. And one of the children who passed, their estate plan said, leave everything to my husband. And he was a nice enough guy, so that wasn't the issue here. But it was probably not what they really wanted to happen. They probably would have preferred something else to happen. It's just, she owned it, it went to her husband. The issue came up though when the second of their children passed away, was a single parent, and their estate plan said everything goes to my son, right? Well, their grandson, when this planning was originally done, was really young, 5, 6 years old, something like that. And they could have never foreseen that after 20 years, he would develop a really bad substance abuse problem. Well, the family came in to talk to us because it was time to sell this property. They own it 4 ways, 2 of the kids, a son-in-law of the original parents and their grandson. And the grandson's addiction issues, they wanted to make sure that, not that he couldn't receive benefit from the proceeds of the sale, but that he couldn't be in control of the proceeds from the sale because they were very worried he was going to use it to fuel his addiction. And they asked, well, how do we stop this from happening? Well, he owns that quarter of the home. He would have to willingly give up access to those funds. And that was not going to happen, right? And it's very unlikely to happen in most of those situations where somebody has an addiction issue, right? And it could, I suppose, but it's unlikely. So while they were doing this planning, gifting it to the kids, well in advance of needing care, with the anticipation that we want to keep this safe from our long-term care expenses and make sure that the value's there for the next generation, they couldn't have possibly foreseen all of these things coming up. So by gifting it to the kids, you're just not doing any of the contingency planning. And so that's where we tend to look at using what's called an irrevocable trust to do that instead. Well, if you're looking at using irrevocable trusts, you can't be your own trustee. You might still name the children as those trustees, but you maintain certain decision-making things like you can fire your trustees if the kids are causing problems. You can change the beneficiaries of that trust potentially too, depending on how it's set up, right? So you have the ability to still do a lot of that planning and protect yourself just as much as you're protecting that asset. That irrevocable trust is still included in your estate when you pass away. So that means you get that step up in basis for the kids, and any tax concerns about capital gains can be wiped away. But most importantly, your terms of your trust, your irrevocable trust, can lay out what happens if some unforeseen circumstance comes up. Like, what happens if somebody passes before you? What happens if somebody has an addiction issue or creditor concerns, right? You can protect them both from themselves, potentially in the case of like a responsibility or addiction issue. You can also protect them from other people like creditors or divorce. So you can protect the assets from all of those things that you couldn't have foreseen or you wouldn't have wanted to foresee happen, right? Even if they were the most responsible people in the world, why not add that protection in? So it still counts against the 5-year look back when you do that planning, but just like that gifting would, but you have a lot more protection over the assets that you do that. And then if that money needs to come back in some way because, the penalty period is too difficult, you didn't make it the 5 years, that money could still be there for you for that purpose, to return it if need be. So it's a lot safer than just gifting that money, certainly. But so that is a way then that those assets do not count against your available assets. So, in the example of Bill Gates, right? I mean, in theory, he could, as long as he was making it out 5 years in Wisconsin, could transfer everything over to an irrevocable trust like that, which he has trusts for a lot of different reasons than that, but you get my point. He could have things protected from care. So I am running over on time here a little bit, but just a couple quick things to wrap up here. Again, you will receive that handout of the home that I was talking about, and a feedback form where you can let us know that you'd like to set up time for an initial consultation. Again, those are complimentary. If you would like to attend our in-person public seminar in Green Bay next week on Wednesday at the Neville Public Museum, you can sign up for that at estateplanninglive.com. And again, there are 2 sessions, 2 p.m. and 6 p.m. for that. So with that, I will let you guys go and enjoy the rest of your day. But thank you for joining me, and I hope to see you guys in person next week.